It was an incident dating back 13 years with tragic consequences for a child and his family. The child has been referred to as Y to protect his identity. The case concerns a clinical negligence claim brought on behalf of Y by his mother and her friend against the Gibraltar Health Authority. The incident in question dates back to February 2012, when Y, then 11 days old, was taken to A&E at St. Bernard's Hospital with persistent vomiting. He was seen by a doctor at A&E who consulted a pediatrician on the phone. Y was discharged with advice to change to a different formula feed. There was a dispute about the adequacy of the discharge advice. 4 days later, Y was readmitted with a life-threatening condition caused by a salmonella infection spreading to his brain. He suffered severe brain damage with lifelong consequences. The claim is for more than £10 million. A trial on liability is scheduled for October 2025, focusing on whether Y should have been discharged on that day in February, or alternatively, whether the discharge lacked appropriate safeguards and worsening symptoms advice. That's the broad outline of the case. But now, Y's legal team has sought disclosure of emails and documents referred to in a draft, unsigned witness statement of a former consultant pediatrician, Dr. Annie Dye. In that draft, Dr. Dye states that senior pediatric staff had repeatedly raised concerns with GHA management about the absence of an on-site pediatrician, especially during out-of-hours periods such as weekends. However, these remarks were omitted from her final signed statement, reportedly following advice from her professional body to maintain neutrality. Judge John Restano, however, concluded that although the concerns raised by Dr. Dye were serious, the evidence provided by medical experts indicated that even if a pediatrician had physically examined Y, he would still likely have been discharged with safety netting advice. He said the experts agreed that the system used at St. Bernard's, where the on-call pediatrician was available by phone, was consistent with practice in UK hospitals, although not ideal. Given this context and the difficulty in retrieving old documents, the judge found that the disclosure sought was neither proportionate nor likely to affect the outcome. The specific disclosure request was dismissed. The substantive hearing will be held later this year.